Hello friends and students, how are you? Welcome to Legal Matters by Sai Babu Sunkara. Today we are going to discuss the value of the evidence of a child witness. Please remember, according to Section 118 of the Indian Evidence Act 1872, so who may testify as a witness? Section 118 says, there it says, if the court is satisfied that a person, a child, a dumb witness, an insane person, if the court is satisfied that he, by reasonable questioning, that this man can answer the questions in a rational way, and if he cannot answer due to old age, infirmity, disease, all these things, he will not allow. If the court is satisfied, yes, that this man or this child is able to answer the questions in a rational way, definitely court can allow anybody. Therefore, only thing is the court is to be satisfied. It has to be satisfied. So, in so many cases, the children who are victims of rape, the children who have seen the incident of their father committing the murder of their mother, definitely they will come before the court and they will depose the evidence, and basing on their evidence, so many convictions were also given. But the basic fact is, please remember, Bombay High Court judgment today we are going to discuss, wherein it held that child is a pliable witness. In Telugu we call it as vanchadagina. Ante normally they will be twisting to any side. They can be bent on any side. That is the problem. With a child witness, it can become a tutored witness. So you have to be utmost careful while dealing with the evidence of a child. So this is what is held by the Bombay High Court Justice Anuja Prabhu Desai, while dealing the appeal filed by Janardhan Kapse. So he is represented by Advocate Ravindra Chalke. So these are Marathi names. So they held that child is a pliable witness. So the evidence of the children should be weighed with cautions, or with so many precautions, right? So ultimately, now we'll go to the case, what happened. So this Janardhan Kapse, he has been actually alleged under to have committed the offences of section 376, section 354 of the IPC, as well as section 4 and 8 of the Prevention of Children from Sexual Offences Act 2012. So actually what happened is, the victim's family is staying in the 4th floor and the accused family is staying in the 5th floor. There was a quarrel between them regarding that toilet water actually coming into or flowing through the walls. So some seepage water is coming into the floor, 4th floor. There was a dispute, quarrel between them. Anyway, so it was alleged that he has molested her, he has outraged her modesty on one side, and he has ultimately raped her. This girl is aged about 5 years old, right? So the lower court, the trial court, basing solely on the statement of the child witness, they have convicted the accused. So basing on which they came for appeal before the Bombay High Court. So Bombay High Court, after perusing the judgment and after perusing the statements that is the evidence recorded before the court, here the main point comes. So here what happened is, the child told before the court that her parents told her how to give the statement. Her mother gave her instructions as to what to tell if the police questions her, and this girl noted down the same, and when the police asked her the questions, she has replied the same. And this fact was admitted by the child before the court, right? She admitted that her parents told her how to depose before the court and how to depose before the police also. So that means she is a tutored witness. So the court held, Bombay High Court held that the child is a tutored witness and no credible reliance can be placed on her evidence. And moreover, the child's mother or informant, they have got a dispute over the toilet dispute in the 4th floor and 4th floor. So therefore, this may be also possibility, there is a possibility for false implication. So trial court erred in believing the only version of the child witness. Of course, according to section 29 and 30 of the POCSO Act, says the presumptions are there. The court has to believe unless a rebuttal is there. But whatever it is, so since the child is a tutored witness, so the conviction given by the lower court is set aside, appeal allowed, and the conviction given is dismissed. So anyway, even though it's not a good case, here we have to appreciate the defense advocate for raising 2 points. Normally we will be discussing. So there were quarrels between those two people. This girl, this child was tutored. Enough. These 2 points are enough for acquittal of the case. The lower court, of course, did not agree. But anyway, justice was done in the higher court. Good judgment. Please read it and enrich your legal knowledge. Thank you very much.